Go!
Hi, welcome back to another exciting episode of Trademark College with Attorney Steve. All right, trademark at issue. This trademark was refused by the United States Patent and Trademark Office. Let's take a look. Trump too small. Trump's you-know-what is back in the news. So somebody came up and wanted to get a federal trademark for Trump too small. They wanted to put it on t-shirts and sell it and get nationwide rights. That's what you get with a federal trademark. You get nationwide rights to prevent confusingly similar knockoffs, okay? You can see they have some things here. The front, the name is what was sought to be registered, Trump too small. I think you guys remember that. What? Yeah, there's no problem here. Yeah, there's no problem. You guys remember that. So anyway, this trademark was refused by the United States Patent and Trademark Office. Here it is, the USPTO decision. It was appealed to the United States Supreme Court. This applicant for the trademark says, look, I'm commenting, I'm criticizing. No one's going to take it. No one's going to think it's Trump. What's the deal? Here we have it. The USPTO is represented, for those of you who don't know, by the Department of Justice. So they're representing them in the Supreme Court case. I think arguments are set for, I don't know when arguments are set. They're coming up pretty quick, I think, and probably a decision, probably mid next year. So we'll see what happens. Question presented. Here's the issue. Straight out of the Supreme Court docket here. Section 1052C of Title 15. We're talking about the Lanham Act here. In pertinent part, a trademark shall be refused registration if it consists or comprises of a name. So here they're using the Trump name, identifying a particular living individual except by his written consent. So if you get consent, that's one thing, but I don't see that happening. The question presented is as follows. Whether the refusal to register a mark under Section 1052C violates the free speech clause of the First Amendment. So we're weighing the Lanham Act versus the First Amendment. So we've got two federal issues here at hand, weighing competing interests. That's what the judges and the justices will be doing. In the amendment, when the mark contains criticism of a government official or public official, okay? So the USPTO at the lower levels, they denied it on two grounds. One, false suggestion of a connection. Trademark Act Section 2A bars registration on either the principal or the supplemental register of a designation that consists or comprises of matter that may falsely suggest a connection with persons, institutions, beliefs, or national symbols. To establish that an applied for mark falsely suggests a connection with a person or an institution, the following is required. The mark sought to be registered is the same or a close approximation of the name or identity previously used by another person or institution. That would be the Trump name. Two, the mark would be recognized as such in that it points uniquely and unmistakably to that person or institution. Yes, I would say that qualifies. Three, the person or institution identified in the mark is not connected with the goods or services performed by the applicant under the mark. That seems to be true. Four, the fame or reputation of the named person or institution is of such a nature that a connection with such person or institution would be presumed when applicant's mark is used on its goods or services. Okay? So again, it's kind of creating this false connection that maybe Trump is somehow involved and consents. And so that was one ground for refusal. The second ground, so that was under 2A. This is under 2C. This is the Trademark Procedures Manual, and you can find out these things. Section 2, name identifying a particular living individual. Trademark Section 2C bars registration on either principal or supplemental register of an applied for mark that consists or comprises of a name, portrait, or signature identifying a particular individual without that individual's written consent. For purposes of 2C, a name in a mark identifies a particular living individual if the person bearing the name will be associated with the mark as used on the goods or services because, one, the person is so well known that the public would reasonably assume a connection between the person and the goods or services, or two, the individual is publicly connected with the business in which the mark is used. Section 2C applies not only to the full name of an individual, but also to any first name, surname, shortened name, pseudonym, stage name, title, or nickname that identifies a person, particular living individual. So As far as I'm aware, this shirt is already for sale. There's nothing preventing this guy from selling the T-shirt. I mean, I think it has some comedy value to it. But what he may not be able to do is to get a federal trademark, and this is going to be up to the justices to make that decision. So stay tuned. We'll give you an update when the case comes out. I expect that the Supreme Court will probably uphold the refusal, and this guy can go on selling the T-shirt, just cannot get the federal trademarks. We'll see if I'm right. Stay tuned. This is general legal information only and not legal advice. Hope you enjoyed this. Feel free to share this video on your social media networks. Thanks a lot, guys. Have a great day. Bye now.